a note indicating that we do not have YouTube, that we are now recording to the computer system, and we'll post it later. So we'll go ahead and proceed. I will call the case. It's Osborn versus State of Kansas Department of Children and Families and KVC. Let me introduce myself. I'm Gordon Atchison. I'm the presiding judge here today. Joining me are the Honorable Stephen Hill, who is in fact currently the longest serving judge in Kansas. And with us today is Judge Amy Klein, who joined our court 3 months ago. In terms of tenure, I fall in between the two of them, actually closer to Judge Klein than Judge Hill in years of service. This case is set for a standard 15 minutes of argument. The appellant may reserve a portion of that time for rebuttal if she chooses to. And as I think we had conveyed earlier, we will ask the defendants to split that time. Hopefully you all have resolved that in some manner. I will advise you, however, I am not channeling Justice Rehnquist, and I will not cut off counsel if we have questions from the panel or you're in the middle of an argument. So the 15 minutes is sort of a rough guideline. With that, why don't we go ahead and proceed? Ms. Shelton, at the moment, the floor is yours. If you want to reserve some rebuttal time, let me know how much.
3 minutes, Your Honor.
Please proceed.
Thank you, Your Honor. May it please the court, and good morning, Your Honors and counsel. We're here today because the district court dismissed the entire case again at the pleading stage. This is our second time in the appellate court. And in between the first appeal and this appeal, plaintiffs were able to conduct a little bit of discovery. And through the course of discovery, we learned what really is the heart of this case. And that is, it wasn't about a couple of hotline calls and the catastrophic fatality of the 6-month-old baby boy, Aiden Osborn. What the discovery revealed and what is alleged in the amended pleadings is that during the 8 weeks before Aiden Osborn was murdered at 6 months by his mother's live-in boyfriend, Anthony Anderson, the Department for Children and Families, and I refer to them as DCF, and KVC Behavioral, and I'll call them KVC in this argument, they were extensively involved with the child's life for that 8 weeks. They not only came in and investigated 2 hotline calls, there were actually 5 hotline calls. They came in, they determined the child was not safe in the home, but they were going to try to maintain him at home with a written safety plan and with the delivery of services. And
counsel, may I interrupt you there? It seems to me what you have just described is very typical in a lot of child in need of care cases across the state. And is that not everything that you've described so far part of the discretion of DCF to investigate and follow up on these calls and then make judgments about what to do with the facts and circumstances? Why isn't this all discretion?
Your Honor, so this is typical of a DCF response, and it's important to distinguish between the stage of investigation, which is part of their statutory duties, and the delivery of services, which is not part of their statutory duties. The statutory duties are found under 38-2230, and it's part of the SYNC chapter, where DCF statutory duties, which are, they're immune from in this those discretionary acts. That includes the preliminary investigation, immediate steps taken after the investigation, and making a recommendation to the county attorney. So when we look at this particular case, and this is similar to the Waters case, where after the investigation is over, which is the stage of assessing and gathering information, decisions are made. where the liability in this case is not predicated on the investigation that DCF did, and it's not predicated on the decision to leave the baby at home. The liability is predicated on the 8 weeks where they undertook to render services necessary for the protection of the baby. And that's a legal duty imposed by common law, the restatement.
Now, which restatement section are you referring to?
I'm referring to two sections, Restatement 323 and Restatement 324A, which is parallel to that.
So you're saying they assumed a specific duty with respect to this child, the DCF?
Yes, Your Honor.
And what is that? What makes it specific and not like the general duty that they owe to all children in Kansas?
And that's what this case is about. Where does the public duty end, and when does that specific duty get narrowed to this baby Aiden?
So it's your argument then, in every case in which they develop a case plan, then they are liable if they don't carry out that case plan properly under the restatement.
Yes, that once the investigation ends, a decision is made to deliver services, and DCF voluntarily, this is not a statutory duty, voluntarily undertakes to render services for the safety of that child. DCF is under an obligation to perform those services in a non-negligent manner. The question whether they breached that duty or whether it caused his death are fact questions. The issue here today is as a matter of law, whether there's a duty. Under the restatement 323 and 324, like in the Waters case, we're in the
Waters case, let's speak about that. Of course, it was not a unanimous opinion. It wasn't even a published opinion. And it was referring to those two sections of the restatement, correct? But the difference is what? How is this identical to Waters?
It's similar, Your Honor. Sorry, I didn't mean to talk over you. It's similar in that like in the Waters case, DCF created a plan, undertook to render services, and like in the Waters case, in this case, when the mother didn't comply, there was a meeting on March 25th, 4 weeks before the baby's murder, where there were observations of physical abuse in the baby's face. Mother wasn't complying with the plan. There was a 4-week period of time where DCF should have, our allegation is, should have taken action at that point in response to mother's noncompliance. So like the Waters case.
Now, Waters is horizontal precedent to us. It's certainly not binding. But there is a case that is binding upon us, and that's Roe. You're familiar with that. And how are those, it seems to me that all of the actions that you've talked about in this particular case were done in Roe. And the Supreme Court ruled that those were discretionary. And therefore, you could not pursue a tort claim against the, I think that was SRS back then.
If I may, Your Honor, that in Roe, baby Roe, the Kansas Supreme Court found, from my perspective, a duty was owed. However, the duty was incidental. It was in that case, SRS simply made an oral promise to monitor another agency's delivery of services. And the Kansas Supreme Court said that's just an incidental undertaking, and that didn't give rise to liability. SRS just, and compared to this case and compared to the Waters case, where DCF actually undertakes to deliver its own services, and in this particular case, it even brought in its partner contractor to help deliver these services. It was a written plan, not an oral promise. It wasn't an incidental undertaking. The Kansas Supreme Court in Roe defined the scope of the duty owed by, in the Roe case, as what they promised, which is simply to monitor. In this particular case, when DCF undertook to render services, there was a condition in that written plan that DCF would remove that child if mother didn't comply with the terms of the safety plan. That's what we've alleged. And all of our facts are taken as true at this stage of the pleadings. So in essence, from our perspective, Your Honor, the Roe case actually supports the concept that DCF at some point, when they undertake to render services, does owe a duty specific to that child. But if the undertaking of that duty is only an incidental undertaking, oral promise, that's the example we have in the Roe case, then that doesn't give rise to liability. That's the scope. What was that oral promise? They promised to monitor another agency, but in this case, the undertaking, which was much more extensive, as we pled in our second amended pleadings.
Now, Roe was not a unanimous opinion, was it?
Your Honor, I don't think so, but I don't recall exactly, no.
In fact, Marla Lukert dissented in that particular case, did she not?
Yeah, I believe so, Your Honor, and yes.
And do you, I guess, if you aren't aware of it, do you rely upon any of the statements in the dissent, her dissent, in your argument today?
Well, Your Honor, I'm familiar with the Roe case and the majority opinion, and I read the dissent. I'm sorry that I'm not as familiar with the dissent as I am with the majority opinion, but I believe that was if I recall correctly, the dissent. Yes, I'm sorry, Your Honor, I don't want to say something.
If I could, and I don't want to push you along too fast here, but I do want to ask you a question. You're making an argument under a different section of the restatement second of torts than was done in Waters, and that's section 411, are you not?
That's the negligent, higher negligent supervision of an independent contractor. Yes, Your Honor. Explain
that to me, please.
Yes, Your Honor. DCF, when they undertake, they have a duty to, under the restatement, to hire, to use reasonable care in hiring a competent contractor to provide services on their behalf. And if I recall correctly, in the Roe case, that was it wasn't raised at the district court level, so the appellate court, the Kansas Supreme Court did not deal with it, but they didn't discount that as a viable theory of liability against DCF. They were under a duty to use reasonable care in selecting and monitoring and supervising their independent contractor.
Ms. Shelton, does the doctrine of professional judgment figure into this case at all with respect to either discretionary function or ministerial performance of duties, in your view?
So the Kansas Tort Claims Act, the rule is liability, and the exceptions, it's the burden on DCF to prove an exception. And with regard to discretionary functions, that goes to decision-making, policy-making that's been described like that in the case law. So the standard of professionalism, I think, would certainly be a measure by which we could use on the merits of the case to prove or disprove whether they fell below a standard. But as far as discretionary versus ministerial, I think the analysis there is to look at the nature and substance of the discretion used. I gave two examples in my brief. One was the Allen case, authored again by Judge Levin, where, for example, the decision to mop the floor was discretionary, and whether or not that carried with it a level of professionalism was really not discussed in that case, but could be used as a standard. But the liability, there's not like, DCF is immune for discretionary decisions. Whereas the actual mopping of the floor, or applied to this case, the actual delivery of services is considered ministerial. I would like.
No, go ahead.
It seems that the case law supports the proposition, though, that if DCF is under a legal duty, that the discretionary function exceptions do not apply to immunize them from liability.
At least as set out in your the various iterations of your petition, the formulation of the plan for AO was sort of an interdisciplinary function that involved, for the most part, skilled professionals, social workers, mental health professionals, and others who looked at the environment and said, this is what we need to do to protect this child while allowing the child to remain in the household. Is that a fair characterization of what you've alleged?
Yes, it was a team of social workers in collaboration with their independent contractor, KVC, to try to come up with the best plan possible. And our liability is predicated on the creation of this plan. In fact, I think the facts alleged indicate that DCF and KVC started out well. They did what they were supposed to do, to make an assessment, create a safety plan, and try to address the crisis that was developing in the home. Our liability is predicated on DCF and KVC completely dropping the ball in what appears to be basically washing their hands of the case after about March 5th. Whereby
you're going into your rebuttal time at this point. I just let you know that. And so I think we'll, unless there are other questions from the panel at this point, we'll turn it over to the other side. I take it, since you've unmuted yourself, Mr. Alderburn, you're going to be the lead-off advocate here.
Not necessarily, Judge. If Ms. Haffley.
Okay. Well,
first, that's fine.
I think we had indicated we wanted the two of you to figure out how you wanted to divide your time. Why don't you enlighten me as to what y'all are going to do, one or the other of you at least?
Sure. Before this, Ms. Haffley and I agreed that we would basically half and half, so 7.5, 7.5.
All right, and who's going first?
Well, I think given that the majority of the questions seem to point to my client, it might make sense if I go first, unless Ms. Hatley has a disagreement.
All right, well, let's go ahead and do that. And like I said, I'm not going to cut anybody off in mid-sentence if we've got questions. So why don't you go ahead and proceed?
Fair enough, Judge. Thank you. I will put I do have a stopwatch next to me here, so I don't run too far into Heather's time.
That's right. I'm watching the time. I'll take care of that. Good
to hear. Thank you, Judge. Again, Your Honors, Mark Altenburnt on behalf of the Kansas Department of Children and Families, or DCF, as it's easier. Before I get started here on my arguments, I'd like to address a few things that counsel indicated. It seems to be that when you drill down to the bottom, counsel's argument is DCF did too much. Okay, her argument is the investigatory process clearly falls within the bounds of the Kansas Tort Claims Act. Responding to hotline calls, maybe visiting families, having social workers go over, or mental health professionals go over. All of these things, counsel agrees, fall within the discretionary function exemption of the KTCA. However, if a written plan is created for an individual, then suddenly it's no longer within the KTCA, then the state has liability. The idea that the legislature would enact a law that provides immunity that only goes as far as trying to actually assist the child at issue seems backward to me, Judge. And not only does it seem backward to me, counsel hasn't cited to any case law, any statutory law, anything.
Counsel,
yes.
May I interrupt you?
Certainly.
From my days on the trial bench and hearing these types of cases, it's my memory that these case plans change, sometimes frequently as circumstances change.
Is
that correct?
That is very correct. And the changes in those plans are dictated by, as Your Honor indicated, changing circumstances. Changing circumstances necessarily impacts the decision-making of the social workers that are involved, the mental health workers that are involved, sometimes the police department that's involved. So it's always kind of a snapshot in time as to what's in one of these plans. But it's not, as counsel seems to want to indicate, it's not a set in stone, this is the plan that exists. As Your Honor indicated, it does change, and the manner in which it changes is directly based on the professional expertise of the social workers, of the mental health professionals that are involved.
Counsel, let's talk about that a little bit, because it's my understanding that what they're claiming is not that there's an issue with the development of the plan, but just simply monitoring compliance. I mean, we're not talking here about changes that were made to this plan, right? It is simply just a claim that, I mean, at this point, are we just checking boxes? I mean, we're looking at, did the mother take the child to pediatrician appointments? No. Did the boyfriend allow DCF into their home or not? Did the mom move into a place where it was safe for the child to be? No. I mean, how much discretion is really involved in looking at the compliance issues here? What am I missing?
Well, Judge, this directly goes to the duty issue. Kansas jurisprudence has dealt with these issues repeatedly, and they've given the same answers repeatedly. Even if these services are rendered negligently by the social workers, by the mental health professionals, even if they completely fail to fulfill their own obligations, they still have immunity because they're all discretionary functions. This can't be confused with somebody mopping a floor, as counsel wants to try to combine or compare the two issues. The court said very clearly, mopping a floor is something that really anybody can do, and so they have to do it in a reasonably safe way.
But couldn't anybody determine whether the mother actually did what she was supposed to do in the safety plan? I mean, you wouldn't need any kind of specialized training just to check to see if she took the child to the doctor or if the boyfriend's allowing DCF even in the home, right? I mean, you don't need specialized training and experience for just compliance monitoring, do you?
Well, yes, to be perfectly frank, Judge, if you didn't need the training and the education and the experience to do this monitoring, what we can't do here, and what counsel's trying to do is she's trying to take one piece of what is a larger investigatory process. She's trying to take one small piece, separate that piece, focus on that piece, and say, this is what you did wrong, and this is what falls outside of the public duty doctrine. Because of this small piece, you have a special duty to this child. And Kansas case law is clear. DCF doesn't, you can't take this one little piece out of this larger umbrella of services that fall under the ambit of what DCF does and say, because of this one piece, for example, in this case, because you created a safety plan, you have therefore done something affirmatively that makes you liable. That doesn't jive with case law and how the legislature has dealt with the Kansas Tort Claims Act.
Mr. Alterbrandt.
Oh, I'm sorry.
Looking at 382230, which is what we're sort of talking about as the statutory duty here, it has several components. And it seems to me there is a component that comes into play after there is reasonable grounds to believe a child is neglected or abused. And in this case, there was at least alleged in the petition, a determination that this AO was a child who reasonably might be believed to be neglected or abused. And then the statute goes on to say, if that's the case, immediate steps shall be taken to protect the health and welfare of the abused or neglected child.
Correct.
How is that immunized under a public duty doctrine? That is not a duty owed the public. That is a statutory duty owed that particular child, and in this case, AO, isn't it?
Well, Judge, according to jurisprudence, including the Kansas Supreme Court, it is a duty owed to the public.
What jurisprudence specifically are you relying on?
Well, the Roe case that we've been speaking of. We've also got the Bulliard matter. We've also got Kansas appellate court cases such as, the PW versus Kansas matter, which is another Supreme Court case.
Now listen, let me stop you right there. On PW, did not the court say that this general duty there is a possibility that a general duty can become a specific duty as circumstances? Did not the Supreme Court say that?
Oh, Judge, DCF is not arguing. We're not arguing that there is no set of facts that could exist that would take the public duty to a duty to the child. I'm sure that some circumstance can arise where that would take place. We haven't found one. The courts haven't dealt with one. There isn't a case that I'm aware of that says SRS owes a duty to this specific child because of these circumstances.
Now, counsel, I know you don't have much time, and I do want to ask you this question.
Sure.
We are here based upon a motion granting judgment on the pleadings, which is a different standard than all of those other cases that you referred to, which I think were all submitted on summary judgment.
I believe that's accurate. Which
is a different standard of review entirely. Now, how is this case, because we're very similar to the status in the Waters case, how do you escape the result that was done in Waters? Well, especially vis-a-vis section 411 of the restatement section.
Well, Judge, the distinguishing characteristic, at least on the surface, between this case and Waters, the judge in Waters, that case, they did what they did there because no discovery had taken place. So what the plaintiff's counsel in that case said is, look, we don't have any idea if things were done sufficient or substantial enough to create this relationship, to make this affirmative action. And so the court there said, do some discovery.
So because there's been a little bit of discovery in this particular case, then judgment on the pleadings was warranted.
Well, judgment on the pleadings was warranted, Your Honor, because the appellant filed multiple amended petitions. I'm guessing counsel put the best facts she could hope to achieve into those petitions. And the facts that are alleged are still not sufficient to create this affirmative relationship. Basically, counsel is arguing that DCF should have removed this child from the home. We've had cases where the mother has accused, in that case, SRS, of not removing the child from an abusive father. And the courts have ruled that that is a discretionary function. And the reason why is exactly the reason I'm sorry, go ahead. But
section 411 isn't really about that. It's about the relationship between DCF and KVC. Failure to supervise what KVC was doing. That's a different question entirely. And has there been any discovery upon that?
Judge, there's been discovery on that. Counsel's been given the appellant's been given the opportunity to conduct discovery. And both before the appellant brought KVC in via subpoena and after the appellant brought KVC in as an additional defendant. The restatement, the supervision at the end of the day comes down to, is there a duty? We always have to come back to whether or not there's a duty. In this case, and in the state of Kansas, we privatize our foster care system. KVC is one of the companies that we utilize. By extension, they are also
So my question is this,
Sure.
Then your discretion, DCF's discretion, can pass along via the contract to KVC. In other
Correct.
words, anything KVC does is discretionary and therefore they're immune under the Tort Claims Act. Is that your argument?
Well, Judge, I'm never going to fall back on everything they do. But in terms of investigating and placing children, yes, those would be discretionary functions that fall within the KTCA.
This is absolute immunity then.
It's not absolute immunity, Judge. We've never argued absolute immunity. The case law, Kansas law is very clear. There can be circumstances where immunity does not apply. We're simply arguing in this case, given 3 bites at the apple, because there's a second amended petition and discovery, even if we take all of the facts alleged as true, the appellant still has not alleged facts sufficient to create a special duty or special relationship. And that's ultimately what needs to happen here.
I won't interrupt you anymore. Thank you, Judge.
Thank you, Judge.
Judge Atchison, I'm sorry, I didn't mean to interrupt
okay.
you.
That's okay.
You're over your time, and we'll adjust that around and give Ms. Shelton some additional time, and we'll take care of that. But I want to pose to you essentially the same question I posed to her. The Federal Tort Claims Act was the original sort of template or model for the Kansas Tort Claims Act, and they've deviated a lot over the years. But there is a professional judgment rule or doctrine that's accepted under the Federal Tort Claims Act. Does it have any application, or has it ever been applied or construed under the Kansas Tort Claims Act that you're aware of?
Judge, I can't tell you whether that's been construed or applied in Kansas law before. I think professional judgment is always something that needs to be taken into account in any of these decisions. That is one reason why this immunity exists, because it does require professional judgment. Every step along this track is part of the overarching reality that how we handle children that are in these circumstances requires a lot of professional judgment, because you've always got this tug of war between, okay, we absolutely want to protect the child, but we also want to keep the child with the parents if we can.
Right, and that's, I'm sorry to interrupt, but
sure.
That's a judgment that trained mental health professionals, social workers, there may be drug counselors, depending on the circumstances. That's a matter of those trained professionals applying their skills to a particular situation. Would you agree with that?
I would agree with that.
And is that something different from the broad discretionary function immunity, and it falls more into a category of something like professional negligence or malpractice? And should that be treated differently under the Tort Claims Act? Well,
in terms of malpractice, you're running into something a little bit different there. And for individuals who are working for DCF, they can be named personally, and they can be named in their personal capacity as opposed to their professional capacity. And they might have qualified immunity, but that's a different analysis. So in terms of professional negligence or medical malpractice as a similarity, I don't know if I can't sit here and tell Your Honor that the legal analysis under professional negligence would at least fit perfectly in a situation like this. Typically with professional negligence, you're dealing with one or two individuals, one doctor. In any of these child in need of care cases, you're dealing with a multitude of individuals, all of whom have their own specialties, all of whom have their own expertise, and they all work in concert to try to make the best decision possible. So I don't know if that answers Your Honor's question. That may have just been me talking.
Well, it's a question that's out of left field if it's even in the ballpark at all, I suppose. So
I think it's in the ballpark.
I appreciate that. You have kind of far exceeded your time at this point. Do we have any other questions from the panel? Okay. Ms. Hatley, we will turn it over to you. We haven't heard much about your client yet at all. So
I know, yeah. So Ms. Shelton didn't really get the opportunity to put forth her arguments.
Well, maybe you should quit while you're ahead or something.
Yeah.
Yeah, you've got 7.5 minutes. Go ahead.
Okay. Well, I'm Heather Hatley, and I'm here on behalf of KVC, and this is my first time before you all, so thank you for entertaining us today. So in the district court, KVC filed a motion to dismiss on the basis that the claim that plaintiff has made against KVC, which is titled as a survival action as a third-party beneficiary versus KVC for breach of contract, is in fact a tort claim and is therefore barred by the statute of limitations. The second amended petition, which is the first time that KVC was added to the case, was filed in August of 2019. The statute of limitations.
Counsel, let me interrupt you. If I understand the facts correctly, when KVC was brought in, the 2 years from the date of death of AAO had already passed.
It had, Judge, and you took the words right out of my mouth. So the actual statute of limitations ran on a wrongful death claim on April 28th, 2017. And a statute of limitations for a survival claim theoretically ran on the same date. And so our argument, which was accepted by the district court, is that this is in fact a tort claim, not a contract claim. It's a well-settled principle that plaintiff cannot label an action as a contract action in an effort to avoid a statute of limitations that might apply to a tort action. So you can't frame it in a way to avoid a statute of limitations, essentially. And our position is that's exactly what's happened here. And we get to that conclusion based on the pleadings themselves. So when you look at what's alleged, you can look at the causation principles alleged, the facts themselves alleged of the injury. There are definite allegations regarding the bodily injury that would go to a survival claim for a bodily injury survival claim, not some sort of breach of contract claim. When you look at the damages that are alleged, it's this general damages of $75,000, which under Rule 60-208 in contract cases, you need to have more than just the generalized, I'm seeking $75,000 of damages. It says it in the rule itself. In response to that argument, plaintiff argues that she'll submit evidence, have an expert come in and provide evidence of the value of AO's life, how do you live to majority, medical expenses, and those types of things. The damages that she has outlined fall squarely within wrongful death damages or damages for wrongful death of a child, and those types of damages. They aren't contract damages. So contract damages generally, they're pecuniary in nature and they are naturally occurring because of a breach. The idea is that they make a party whole or put it back in the same position that it would have been had the contract been performed. So remote and speculative and contingent damages are not contractual damages.
Hatley, assuming that it actually is a tort claim, what evidence is there, or what circumstance demonstrate that Mr. Osborn knew or should have known before the 2-year statute of limitations had run that KVC had some involvement in the care and assistance rendered AO?
Well, so if we're talking,
or does that even make a difference? Does it matter whether
I would argue it does not make a difference.
All right.
So the lack of knowledge on the part of plaintiff at the time of filing of the whole world of facts does not allow a party to come back no matter what time period after the statutes run to just, oh, well, now I can sue this party despite the fact that the statute has run. These statutes are strict. And if we're talking about the relation back argument, there's no portion.
No, I'm not. Let me rephrase and say, let's, in the scheme of things of this case, was there information available to Mr. Osborn before the 2-year statute of limitations had run that was accessible in some manner to him, that KVC had some involvement in the care to AO, and what is that?
So the answer is yes, there was. So the first most obvious answer is he could have spoken with his ex-wife and AO's mother about the services she was receiving from KVC. Second, I know plaintiff has argued in the appellate briefs, and I can't recall if this was raised at the district court or not, but the idea that the prior appeal and dismissal of the case based on standing somehow prevented them from knowing about KVC. Well, DCF, it's my understanding, and they can chime if they want to at the end here, but it's my understanding DCF in this case initially only contested plaintiff's paternity after AO's mother, in her answer to the petition, indicated that she was challenging the paternity and was trying to revoke the VAP that he had signed. So on appeal, this court found that she was essentially time barred from revoking that VAP, and that his paternity had been established in October 2014 when he signed the VAP. This court didn't establish paternity. It didn't say this is the final finding of paternity or anything like that. It in fact, in the opinion states this is not a paternity action. So the point of saying all of that is that prior to filing suit, a few days before the statute ran in this case, plaintiff had the opportunity as the legal father of that child of AO to subpoena or request records from DCF, from any of the contractors as the parent of the child. AO's mother, yeah.
Let me interrupt you if I could.
Yeah.
In the case plan, was not KVC identified as the party that was going to carry out services?
KVC is identified in the case plan and participated in preparing it. But I think the relevant idea here is that you have this 2 years after a death to investigate the claims. And the case law provides that you have to do a reasonable investigation, and that requires some amount of diligence to investigate the facts of the death and any causation or wrongful parties that could be liable for that causation of the death.
But if DCF closed the door to that by saying, you're not entitled to any of this because you're not the father, is that a fair argument to make?
That would be a fair argument if that was what happened here, but that is not actually what happened here. So you're focusing on what happened during the discovery process where good faith objections were made by DCF to providing information. I'm talking about prior to filing suit, there's no evidence and no argument has been offered at any stage that any effort was made to obtain DCF records or any records at all prior to filing suit. That's really the relevant time that we need to focus on here. And then when you look at what happened here in terms of contesting the paternity, which they didn't end up having standing to do anyway, that only occurred in the context of this lawsuit in response to AO's mother saying, oh, this actually isn't the father of the child. So prior to AO's mother filing her answer, DCF didn't have that position. That wasn't their position, and there's no evidence or argument to suggest otherwise. So we're talking about prior to suit being filed, when it's the time for a party to investigate the death, investigate the circumstances surrounding the death. They had the opportunity. I mean, there's a statute, I have it written down here, but pursuant to statute, parents or guardians of children are entitled to request those records and have access to those files. And there's no indication or argument or evidence that any effort was made prior to filing suit to get those records and figure out if there was a contractor. It's also well known that DCF uses contractors, and it's not as if there's 100 contractors they use. I think it's a pretty small number of contractors. So as I said, easily we could have discussed this situation with AO's mother, who's also an heir at law and could have been a plaintiff in this case, or requested records prior to filing suit, which is part of the due diligence that any plaintiff who's going to file a suit has to investigate the claims surrounding the death.
You have used your 7.5 minutes.
Okay, well, there we go. If you have any other questions about the arguments we've made regarding polling or relation back, I'm happy to answer.
We'll turn it back over to Ms. Shelton. Ms. Shelton, I'm going to extend your rebuttal time some here since we kind of extended Mr. Altenberg, if you want. So please go ahead.
Thank you, Your Honor. I appreciate that. I'd like to respond first to DCF and then KVC. Real quickly to DCF. First of all, I had the opportunity to review the Roe opinion very quickly, and in that dissent, Judge Lukert talked about, there was a duty, and the scope of the duty was a factual question, and we're here on the motion for judgment on the pleadings where all the facts are in our favor with all inferences. So the only question of matter of law is whether there's a duty, and in this case there is. Secondly, Mr. Altenberg suggested that there's discovery. I'd like to point out to the court from the record that there were motions to compel. DCF didn't turn over any ESI. I don't have the actual referral. There was a lot of contention over discovery that wasn't produced to plaintiff. So I don't think this is all that we're going to find if this court allows this case to move forward. Now, so if I can turn to KVC. Before this case was filed, Mr. Osborn didn't have an opportunity. He was shut out. He was shut out of the KVC's plan. He was shut out from the mother. And I point out there is evidence in the file, and that is when DCF filed their answer, they actually attached a couple of pages of a confidential document showing that DCF was trying to pursue 2 other men for child support. And Mr. Osborn's name is nowhere in that exhibit. So DCF took the position while the baby was still alive, that Mr. Osborn was not the father and shouldn't have access, and as an extension of that, would not have had access to information that might have given him some information that a contractor was involved, that might have been a party in the case. With regard to framing this action as contract and tort, so I don't disagree that normally in a contract case, commercial litigation businesses, that the damages are pecuniary, but that's not an absolute rule. And in this particular case, and there was an actual contract between DCF and KVC for KVC to provide services that would keep the child safe, prevent child abuse, keep the family out of the DCF system. The duty to provide services in a workmanlike manner was implied in that contract. KVC held themselves out as specifically qualified to provide these services. The duty—
Now, counsel, let me stop you right there, because even if it is a contract, even if we agree with you that this gets around the 2-year statute of limitations by contract, aren't you still stopped? Because counsel for DCF argues that their discretion, their immunity, is then passed along by contract to the contractors. So even if it is a contract, if DCF is immune, then KVC is immune.
So in a contract action, so the Kansas Tort Claims Act applies to a tort. There's no basis for immunity by DCF or at KVC, by extension, to be immune for tort. We're not talking about a tort, but there's nothing in the Kansas law that suggests that there's immunity in a contract action. It's a contract. So immunity applies to personal injury, tort, those types of causes of action. And there's nothing raised in the briefs to suggest that the government immunity applies to a breach of contract.
But as I read your second petition, it all sounds in negligence, does it not? Not all of it. We actually attached the contract, and the nature of the contract, KVC agreed and promised to deliver services to prevent child abuse. When KVC breached that by not delivering or delivering deficient services, through negligence, through their negligence.
Well, if we look at the duty that KVC had, the duty was to provide services to prevent child abuse, keep the child safe. That duty arose out of contract. There's also a legal duty under common law. There's a contract duty due to the nature of this particular contract to keep these kids safe. Because the duty arises out of contract, hence, due to the nature of this, you know, when KVC.
Wait a minute, how can you have a common law duty and a contract duty? It's either one or the other, isn't it?
I don't think Kansas law suggests that you have to pick either or, especially at this stage of the litigation. In this, because of the nature of the contract, was to basically create a safety net to protect the child from physical harm. Why wouldn't this be like a contract to provide a bodyguard for someone? And here, KVC did that by the delivery of services. A bodyguard who let's say the bodyguard shows up drunk and the person that's trying to protect gets hurt. Why wouldn't that be a breach of contract due to the duty arising out of the agreement? It would also give rise to a tort under those circumstances. So to answer your question, I don't think it's either or when it's contemplated that the promisor is trying to protect the in this case, the beneficiary of the contract, and the protection went to the physical safety of the child and the emotional well-being. That was the nature of the contract. That was the consideration for this contract. It can't be said that the parties didn't contemplate that a failure to live up to their promises in the contract wouldn't result in child abuse, child neglect, and ultimately, in some cases, horrible catastrophic fatalities. That's what they agreed to do. That's what they said they could do, and that's what their promise was. So the idea that bodily injury or emotional suffering can never be a contract damage, I don't think is supported in the law, because the analysis is, what did the parties contemplate at the time they entered the contract? And if KVC is going to be the bodyguard of these children as against child abuse, then it's reasonable to assume they contemplated, if they fail to do their job, what's going to happen? The children are going to be maltreated. The crisis is going to develop. They talk about it in their contract. In fact, the contract even states, without our intervention, a crisis may develop. Well, what does that mean? That means that a crisis develops, children get hurt, physically hurt. So I hope that answered your question.
In the absence of any further questions, why don't you take about 2 minutes and sum up your case for us, if you want to.
Thank you. I'll assume no questions.
I don't hear any. Go ahead.
Thank you. In this case, the district court made a mistake when it ruled that DCF did not owe a duty. The duty here arose when DCF undertook to render services during that period of time after the investigatory stage was over. DCF owed a duty. Whether they breached the duty or whether the breach caused the injuries, that's a fact question for the jury. The only question before the court, because of this, we're at the pleading stage, is whether or not a duty was owed. The is not immunized. They haven't shown a discretionary function exception applies here. And as I argued earlier, when DCF owes a legal duty, the Kansas Tort Claims Act, those exceptions don't apply. And the district court made a mistake in finding that DCF, the providing of preventive services should be lumped under the umbrella of their statutory duties to investigate. I don't think the Kansas law ever draws a bright line between children not in custody and children in custody. And this is the period of time that the child was in mother's care when DCF voluntarily undertook to render these services, and they should be held accountable for delivering negligent services. With regard to KVC, the question is there any viable theory of liability pled? And there is, contract and in tort. I don't have to elect at this point between the two. The contract actually attached a copy of the contract. As I said, there's really not a dispute. There was an actual contract, what the services were for. The baby was a third-party beneficiary that had standing to enforce the contract. Damages. And in this case, when KVC promises to deliver services to to be the bodyguard of this little baby Aiden, they should be held accountable under the breach of contract for the bodily injury that occurs when they deliver deficient services. Regarding the tort action, I haven't spoken much about this, but I think Kansas law is fairly clear that the tolling of the statute of limitations occurs at that point in time when Mr. Osborn could not just file, but successfully prosecute the tort claim to a successful conclusion. The mandate from the Court of Appeals came down December 3rd, 2018. We filed our amended pleading, adding KVC as a party within 9 months of the mandate from this Court of Appeals. Had the Court of Appeals affirmed the trial court's decision in the first appeal, Mr. Osborn wouldn't have been able to prosecute this lawsuit. That was the first point in time that he actually could successfully file and successfully prosecute his lawsuit. And for that reason, the statute of limitations tolled until that date under the particular circumstances of this case.
Okay. Thank you. I appreciate the summation. We will go ahead and take the case under advisement. We appreciate the briefs and the arguments. This raises challenging issues for us, and we will get a decision out as soon as we can. Thank you all. And we will proceed to the next case.
Thank you.
Thank you, Judge.